suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
David Whiting is here to answer your legal queries. He is a Melbourne solicitor. Good morning, David. How are you?
Very well, thank you, Raf.
You had some homework?
I did. I had Paul from Moorabbin. Paul was ringing for somebody else, and the situation was the people who were talking about de facto couple separated in 2019. What were the options for bringing a property settlement claim? And the answer is that the starting proposition in de facto property claims is that you have 2 years from the date of separation, unless the court expands the period. The court will expand the period if there is hardship and you can explain the delay. Now, the fact is that if there are children, and if the children are going to suffer hardship as a consequence, then you'll get a consent to extend the period. Doesn't mean you can't do a deal.
No.
And the 2-year time limit doesn't relate to parenting, just to property.
And I think his query was that he said that he had not heard from his former de facto partner, and he was curious. So could that partner still go to a court?
No, that was another call that we had.
Oh, was it?
Where they'd been separated for years and years and years, but never got divorced. And that particular one was that you can bring a claim within 2 years of the divorce. So, yes, no, Paul was straight de facto, 2019 date of separation, can I bring a claim?
His mind's like a filing cabinet with all these files that he can just access. It's this terrifying feature for some of the people I know with legal training. Let's kick off with Adam, who's in Macedon Ranges. Go for it, Adam. What's your query?
Morning, gentlemen. My brothers and myself have inherited some money from a sale of a house of my mum. Now, one brother has a house already in New South Wales, but he's also living in England. He was wondering if he gets taxed if he takes the money over to England and purchases a dwelling over there.
No, he doesn't, is the answer.
No?
It gets a bit interesting. If there had been, let's say it was a holiday house, and instead of selling the house and distributing the proceeds, you decided, well, you could all share at a holiday house on the north coast of New South Wales, then from a tax perspective, the estate would have been considered to sell his interest and get a tax bill. But because you're distributing the proceeds, the tax issue's already been dealt with, he has no tax consequences.
And that will be deposited into an Australian bank account and then transferred from that bank account to England?
Yeah, that's the way that you do it. He may require some evidence over there as to where the money came from. We've just been wrapping up an estate where the beneficiary lives in Denmark, and the bank wanted to know where the money was coming from.
The Danish bank.
The Danish bank, because in Denmark you can pay inheritance tax on what you receive. Right. So Adam, the way you've described it, there is no issue from our point of view, and as I understand it, no issue from the UK revenue perspective.
Good luck, Adam.
Thank you.
Elizabeth is in Hampton. Go for it, Elizabeth.
Oh, good morning, David and Raf. I have a question relating to a pool fence, and as you might know, regulations are changing for pool fences. So on our boundary with our neighbour, the pool fence has to be modified, which is fine. We're happy to pay for it ourselves, but the neighbour's obstructing and saying he doesn't want anyone to enter his property to be fixing the fence. He doesn't want anything to be put on his side of the fence. We have to modify it entirely on our side. So it leaves us in a difficult situation because this is a council regulation we have to comply with, and we've also ordered the extension to the fences, which is how it has to be modified, and the fence is ready to go, but we've...
Elizabeth, the problem is that you want your boundary fence to also be your pool fence, isn't it?
Well, it's... the pool has been built near the boundary fence.
No, I understand, but you don't want a boundary fence and a pool fence. You want the one kind of fence for two functions.
That's right, yes.
Yes, right?
Yep.
Now, what you would need to do is you'd need to follow the Fences Act requirements and say there's a legislative requirement I need because the
Right.
fence needs to be modified. So a
Yes.
fencing notice followed by a fencing summons and away you go.
Right.
Wow.
Okay.
Right?
Is she
And
likely
the
to
neighbour
win?
would need
And
to...
no, what Louine's going to have to pay
Right.
because it's
Yes.
Elizabeth's needs that are requiring her boundary fence to be upgraded to act also as her pool fence.
Does that answer your query, Elizabeth?
I think it does. So he's saying because there are this modification has to have timber extension legs, not very big, I don't imagine, but going on to his side. He's saying he doesn't want to be able to see it. It's about 30 centimetre support for the extension.
Your fence needs to be higher or something else, yes?
Yes, it has to be higher because
Yep.
regulations have changed since it was built.
Right.
Yes.
Yeah, but that's then it will really be a question of whether it's possible to achieve this outcome in a different way. And so that then becomes the question. You're coming along and say, well, the easiest way to fix the problem
Yes.
is to put some extensions on the fence, but we'll put the posts for that extension on his side.
Yes.
And he's coming along and saying, well, hang on a minute, that wasn't the deal.
Right.
So what you might see is whether it's possible to do the work from your side.
Yes, the post, the fence is telling us the post has to go both sides, not just his side. So there was an extension previously, and the fence had to be replaced because it was crumbling.
Yes.
And so when the fence was replaced, we had a fencer lined up who was going to do it at the new regulation height. Neighbour didn't accept it, brought in his fencer, and the fence, this
They
other
found a
fence.
solution.
Yeah, you've still got the same problem, Elizabeth. You want changes to the fence. If you can't accommodate the neighbour and you want to force an outcome, then it's off to the magistrate's court. Fencing notice followed by a fencing summons, followed by a determination by the magistrate. Now, if there is an agreement with the neighbour or there is a court order and access is needed as a result to your neighbour's property, then your fencer gets access.
Good luck, Elizabeth. Good luck. James is in Frankston. Go for it, James. Oh, sorry, James. Go for it.
Are we there?
Yeah.
James.
Yeah, morning, David. Morning, Raf. I've got a fair work question, which I'm hoping you can help me with. My wife started a new job around 10 weeks ago, and 2 weeks ago became significantly unwell due to a mental health issue, which has been treated by a GP and a treating psychiatrist. Well, she's been off for 2 weeks now and has another certificate for the rest of this month. But
That means the whole of October, does it?
Yeah, all of October. The certificate is current until the 2nd of November. But she's since found that the position she's doing has been advertised.
Can I give you a better answer next week, James?
Yes,
I
you
don't doubt that your wife's employment contract, she's in her probationary period.
Correct.
And in the normal course of probationary period, employee can be terminated without a reason being given.
Okay.
But you can still have an issue in your circumstances.
Does that include while on a medical certificate?
Well, if she's only been there 10 weeks, she's probably only got 2 days sick leave.
No, we understand that there's no payment. Obviously, that's not the
But
issue.
the certificate
I
doesn't
will-
stop the employer.
She wishes to go back to work.
Well, no, she wants to be in a position to go back to work in a month's time,
Correct.
at which point there'll be a reassessment.
Oh, well, I would assume so.
Yeah. So, James, I'll give you an answer next week. You'll be well within your notice period. All right?
Good luck, James. Good luck. That doesn't sound like an easy one at all. 1300 222 774 is the phone number. Jill is in Malvern. Go for it, Jill.
Oh, thanks for taking my call. We have a chairperson rather than a committee for the body corporate, and he's threatening to instigate legal proceedings to force an owner to take down a sign on the inside of their window. Is this acceptable or not? Is this legal or not?
Probably not, Jill, but it depends. If you're using the model rules, I'm on your side. But some of the larger buildings that you see around town have owners' corporation rules that talk about what you might do inside your property that can be seen from outside your property. So while the balcony is part of your property, there are owners' corporation rules that say no clothing on the balcony. There are some owners' corporation rules that talk about what kind of Venetian blinds or window furnishings you can have. So if you've got a sign inside, if you've got a member of your owners corporation with a sign inside their property, I don't believe that the owners corporation has the right to tell you to do anything with it.
We can't. The rain on your car roof, Jill, is very loud, so make sure you speak up.
Okay, thank you for that. And what about hanging planters on the outside of the balcony? Is that acceptable, or is that also...
Well, it depends on what you mean by outside the balcony. So if they were to extend beyond the balcony into common property, that's probably a no-no. If they were in the balcony, which was part of your unit, that would be okay.
Okay.
Unless the owners corporation rule says something else, and I think that in East Malvern that's unlikely, or Malvern that's unlikely, because it'll be an older style
Thank you so
unit.
much.
Thank you.
Good luck. How heavy is the rain where you are? Right, where are you, Jill? Are you in Malvern?
Yeah.
And is the rain
It's,
heavy? It sounds heavy.
It's big drops, yeah.
Yeah, it sounds like big drops. Drive safe, stay safe. David's in Hawthorn. Go for it, David.
Hello there.
Hi.
Hi, David. Thanks for taking the call. I have a relative in our family who's living alone as a protected person. He is not a tenant in the home, which is owned by his mother and some other family members. There is no written agreement.
Can we break this up just a second? What do you mean by a protected person?
Right. His mother is in a nursing home.
I'm trying to work out what makes this person a protected person.
Okay, he's living in the family home. He's an adult, and he's living in the family home rent-free, and he has a protected person status.
With whom?
By himself.
But what court order or rule is protecting him? Is there a guardianship order against him, or is there a VCAT order?
There's a VCAT order.
And he is a person affected by a VCAT order, so someone has been appointed his guardian and someone has been appointed his administrator?
No, what's happened is his mother has VCAT orders, and
but Mum's now moved into care. Is that right?
That's correct. Yes.
So you're asking a series of different questions here.
Right.
One of the things that you might consider is an application to VCAT to replace your mother as this relative's representative. Right? If your mum is no longer in a position to act in that role, and he needs such a person, then someone else should be appointed. The next bit you get to is that you say that the property is owned by your mother and other family members.
Yeah.
So there are other people on title, not just your mum?
That's correct, yes.
Good. Then those people have a right of access.
Right.
Everyone who's on title is entitled to go into the property, unless there's a court order that says they can't.
Right. Okay. And what if he does he have the rights to object to?
He doesn't have the right at law to prevent those people coming in.
Okay.
Now, that doesn't mean that he doesn't physically endeavour to stop you. It's just you're a co-owner of the property, the other family members are co-owners of the property, and they have the right to be in the property.
And is that the issue, David, that other people in the family would like access to the property? What's the disagreement about?
Right. Okay, it's a serious situation where this family member has had a past serious mental health issue, and has basically ruined a previous address through squalor.
So where you get to, David, is that what you want to do is go to VCAT and see whether someone can make appropriate decisions about accommodation for this person.
Right.
Right, so it's really a question is, did the person stay in the house, and if so, on what basis?
Right.
Right.
Okay.
Does that answer?
Because you don't have the right, I don't see, presumably he's on the title as well?
No, he's not.
Okay, well, but who's going to throw him out?
This is the difficulty because...
Is Mum competent?
No, Mum's in a nursing home.
There are people in
way
nursing
beyond
homes who are
competence.
very much competent, right?
No, I understand that absolutely, but unfortunately, his mum has advanced dementia.
Good. Then it might be that you might consider getting making an application for an administration order for mum. And
There is an administration order, and she has daughters appointed to look after her welfare and maintenance and protect her assets and pay her expenses.
one of which is the house.
One of which is the house.
Yes.
And we're very concerned from past experience that the house
will be
may be trashed precisely.
And David, what's your interest?
My interest personally,
Well, why else would you ring, David?
yes, my wife owns a fairly large share of the property.
Okay, then she and the
yeah.
other co-owners should consider making an application to VCAT for a guardianship order for the sibling who is, you are afraid, trashing the property.
Right.
Yeah,
Do
it
we
may
need
be
proof for that?
Well, no one's going to put a guardianship order just on your say-so, that your fear of something might happen in the future, therefore I want someone turfed out of a property. You're just not going to get that.
Good luck, David. Doesn't sound like a simple situation. I'll get back to more of your calls on 1300 222 774 in a moment.
ABC Listen.
It's not long now until we all vote in the Voice to Parliament referendum. So do you reckon you know what you need to know?
I'm Carly Williams.
And I'm Fran Kelly, and we're bringing you a podcast to help you make sense of it all.
What The Voice is all about, where did the idea come from?
What it could do and what it definitely won't do.
All the latest facts and fights.
The questions and the answers.
Everything you need to know before you vote.
It's the Voice Referendum Explained. Find it now on the ABC Listen app.
Raph Epstein, mornings on ABC Radio Melbourne.
David Whiting trying to disentangle your potential legal difficulties. Kate is in Lara. Go for it, Kate.
Good morning. I have received a referral to a specialist from my GP. I emailed off to that specialist who's from a private consulting suite, and they've let me know that they won't see me because I don't have private health insurance. Is that fair?
I don't do fair, Kate. I just do law. Kate, they are entitled. A doctor that you go and see is entitled to refuse you to accept you as a patient. In a different scenario, I've had clients come from overseas for the birth of a child, and they're not. They don't have Medicare benefits, and they are not in private health here, and the doctor simply required payment up front. So, as did the hospital. So it's possible for you to enter into a commercial arrangement, but that's the discussion that you need to have. Is a doctor entitled to say, I don't want Kate from Lara as a patient? The answer to that question is yes.
Okay, thank you.
Good luck, Kate. Good luck. Patrick's in Thornbury. Go for it, Patrick.
Hi there. Thanks for taking my call.
Patrick.
Hello. We recently purchased a property, and we just noticed at the final inspection prior to settlement that a large bamboo screening in the backyard that was on our fence line had been cut down. This was there when we purchased the property, so obviously our privacy is reduced. We approached the vendors that had moved out, and they had no knowledge that it had been cut down, and they were mortified. They believe it was the neighbour next door that had cut down this bamboo screening. So they've compensated us prior to settlement for the bamboo screening that's been cut down. But my question is, well, where do we stand with this neighbour next door? We believe what he's done is illegal. He's cut down this bamboo screening, which is about 3 metres high, along the fence line. We can now see straight into his backyard.
Patrick, is it a planting or is it pieces of bamboo? So it's a plant?
No, planted bamboo, yes.
Yes,
yep.
Not like timber, like a timber fence isn't a tree.
No. It's actually planted before the fence on our side.
On your side. The difficulty you've got, Patrick, is that they damaged your neighbour's, your vendor's property, and you've received compensation.
Correct.
So
Well, they took money off the overall sale price.
yeah, I understand. They gave, in a sense, they gave you a discount or they gave you money back as a consequence of no bamboo screening. Yes. So, yes, there would appear to have broken law in the sense of trespassing onto your property. They've damaged property that isn't yours, and there's effectively been compensation paid to you for the loss. You don't have a separate cause of action against your neighbour.
Okay. So the course of action would have been with the vendor.
Yes, it would.
Own the property.
And that would have ended up with a payment of a sum of money.
Yes. Okay. No, but so moving forward, if they were to do it again, obviously then we would have some course.
Yes, you would.
Okay. No problem.
Okay.
All right. Thanks for taking my call. Thank
Good
you.
luck. Good luck, Patrick. So many. It's always amazing. Fences, boundaries, physical boundaries.
Neighbours, that's the problem. If we just didn't have neighbours, would it be a much better place?
No.
Okay.
Kevin's in Wattle Bank. Go for it, Kevin.
Oh, hello. Thanks for your call. What a great segment this is. Just a quick query. I was in a very small superannuation company with a small superannuation balance there last year. They were overtaken or consumed by a much larger superannuation company. I received letters saying that I didn't need to do anything. Everything with my account would remain the same. The transfer would be seamless. And then during the transfer, I received notification that I couldn't access my account online because of the transfer and so on and so forth. So I left it, and then just recently I went online and checked and found that in the transfer, the new company had added insurance products, death and impairment insurance products, and had been withdrawing money from my account to pay for those products.
Yes.
So when I rang up and complained and said, listen, with the old company, I'd made it clear that those were not relevant to me and that they weren't to be on my account, and they had removed them and had been removed for years and years.
So what's the query then, Kevin?
Well, I rang up the company and said that you've, without my permission, added insurance products to my account, and with the charges amounted to some $275, and I asked for that to be refunded. And they said they'd sent me a letter, and also it was in my inbox on my online account indicating that I had...
You couldn't get to, yeah.
Yes,
Kevin, the answer is simple. What's happened is that the insurance company or whoever is the provider of the super fund has changed what's called the default offering, right? And that's the standard offering. And as you got merged in, your non-default settings got changed to the default offering, and you then get the ability to opt out again. I do think you should get the $275 back. If you can't get that resolution with the insurance company that's offering the product, then you go to AFCA, afca.org.au, Australian Financial Complaints Authority, and the insurance company will have the records of the old super fund where you took them out of the package.
Right.
So they didn't need your permission because they changed the default offering. It just tells me that the merger of the super funds wasn't seamless.
No, I guess that's my point of view. The letter said this was a seamless transfer, so I assume whatever...
Well, you've been transferred. That was seamless.
Yeah, the transfers. Good luck, Kevin. Good luck. Try AFCA. I hope that works for you. And Rowan gets final query, calling from Castlemaine. Go for it, Rowan.
Hi, David and Rafi. I'll be really fast. I much of the time. Look, we're thinking of buying a property, an eco village in Castlemaine. At this point, you can move there with cats, but there's got a management committee run by the owners or residents of the place who can decide to change policies. If they change the policy saying we can't have cats and give us 2 weeks to get out or sell the cats, where do we stand legally? We're going in there.
We're talking about a series of owners' corporation rules. Mm-hmm. Is that what it is?
Well, they're rules, yeah. At the moment, the people who set it up, the developers put in place that you can have cats there as they build the property.
No, different point, Rowan. I'm imagining that this is set up as a subdivision with an owners' corporation. And the owners' corporation, like in a block of flats or a tower building or whatever it is, has a series of rules that relate to how the residents must behave.
Yeah.
Now, and it is possible for the standard rules to be changed with the consent of 75% of the unit holders. Right?
Okay.
So if the community in which you choose to move should at some stage in the future pass a resolution with the appropriate majority that says no more cats, then it's no more cats.
Okay.
In the same way as your council could come along and say no more cats. I'm not saying they will, but the council might come along and pass it, and the answer would be, so you either get rid of the cats or leave town.
Good luck, Rowan. Good luck. David in Hyatt is saying, no neighbours or lawyers and the world would be a fantastic place, David. That's a message to you.
Okay, I'll take that on board. All right.
No neighbours and no lawyers and we'd all be better off.
I'll take it on board.
So you've got the one bit of homework.
One bit of homework.
Yeah, okay, fantastic. David Whiting will be back next Tuesday to answer your questions.